This is cause number D1FM 153965 in the interest of Liam through O'Connor. I believe, and I want to make sure with all the parties, but I believe I have 3 notices of hearing today with regard to this. The one, let me see, I may actually have 4. Expand this a bit. All right. I've got a notice of hearing that was filed, one filed on 5/6/22 that shows to be a notice of hearing from Mr. O'Connor on a motion to grant order of non-suit for sanctions. I've got one from similar date indicating a motion to reinstate case on the docket and request for sanctions, pending motion. For interim attorney's fees, a motion to compel from Mr. Thompson. And then I have a second one from Mr. O'Connor as a motion for order of non-suit to be, I thought I had one that was for the motion for sanctions, strike, setting, and dismiss. I may have passed that. Oh, yeah, that's the one that was filed on 5/10. All right, along with a motion filed on 5/10. All right, Mr. Thompson, is there any other matters pending for today that you're aware of?
Yes, Judge. The one that I didn't hear you specifically call out was our motion to compel discovery and for sanctions.
Well, I think that one's probably contingent on your first one, but okay. And when was that notice of hearing set out?
The most recent notice of hearing, Judge, included the notice for our discovery motion, our motion to reinstate, and our motion for interim attorney's fees. And I'll find the date that one was served, but that would be the one that you were looking at last.
All right.
That would be on 5/6, Your Honor. Notice of all 3 of our motions.
Yeah, that I actually called that one. I may not have read everything in, but those are the 3 motions. I've got 2 notices filed on 5/6 and 1 filed on 5/10. And so there's nothing prior to 5/6 that's still set and carrying over to today. Is that right?
That's correct, Judge.
Mr. O'Connor, I've got your 2 motions. Is there anything else that you believe is set for today?
Sir, I'd like to ask for a continuance, sir, because the initial motion filed by Mr. Thompson was about conference. And I had asked by email if he would strike that or dismiss that and reset it, and he would not. And he gave me the notice of hearing. And then because that was already said, I subsequently sent in my notice of hearing for the order of non-suit, dismiss, strike, and sanctions. As I had emailed all parties, and I think all parties except the court knew that Thursdays is my possession day with my son, and I have to go pick him up at school, as well as he has a dental appointment at 4 o'clock. And judging from the amount of exhibits, this is probably going to be, with your Honor's grace, of course, at least a 3 to 4 hour hearing. He requested, Mr. Thompson, a 2-hour hearing. I had requested a 3-hour hearing with the announcements earlier. But as you could imagine, picking up my son is a very important thing for both of us. And I fully want to participate in the hearing, but I think this is all the exhibits and the detail of the arguments and evidence is going to require far more than 2 hours.
Can I respond? So, Judge, she did file a motion for continuance filed an hour ago. If I can briefly respond.
Okay, just a second. It was, he's referring to your motion to reinstate. I assume that was filed on 5/4. Yes, sir, you may respond.
Judge, it's a lengthy court file, and so I'm going to give you some summary on what has happened just this year. This case has been pending.
Well, I browsed through 284 filings.
Well, just the ones relevant, Judge, to what Dr. O'Connor is attempting to do today, which is to delay. We got the custody evaluator's report in January. It recommends vast and sweeping changes to the possession regime.
With all due respect, Your Honor, I have to object because he's providing testimony at this point, and just to preserve my right to cross-examine him at a later point, with all due respect to the court.
Well, honestly, Mr. O'Connor, his comments are not deemed to be evidence. I mean, he's given me a rundown of the things. I do agree that to your objection that it going into the details of what it proposes or not proposes, we really need to address, honestly, before we can get into the, and I've read the motions that have been filed, guys. I've looked at that. I've kind of browsed the index to the exhibits. I didn't obviously do that. But the things that were prior to the filing of the motion to non-suit appear, at least on its face to me, to all be largely moot if I grant the non-suit, then because without some affirmative relief. So let me just, before I go with your continuance, let me just ask counsel one question basically, and that is the reason I looked at 284 items was to see what, and some of that obviously dates back to the original decree, but since the date of the filing on the motion to modify by Mr. O'Connor, I was looking to see if there were any affirmative pleadings on file. I found an original answer. But beyond that, at least as cited in his motion, is that he filed the non-suit at roughly 2 o'clock, and some point after 4 o'clock on the same day, you filed a counter petition. And so is there any other petition for affirmative relief of the case? I know there's lots of things going back and forth with regard to discovery and motions to compel and those kinds of things. But in terms of an affirmative pleading for relief, other than the answer, what else is in there between the day of the answer and the date that the counter petition was filed?
Yes, Judge. So I've done a great deal of research on this because it's a somewhat unusual issue. It's my firm belief, based on the research that I've done, that a motion seeking temporary orders that modify conservatorship, possession, and access is an affirmative pleading, whether it's styled as a motion or styled as a petition. The case that you want to look at on this.
Well, hang on. I will accept that at face value for purposes of what I need to know right now, Mr. Thompson.
So that's right. So, Judge, that will be our position today is, we have various motions for temporary orders. Temporary orders were granted based on our motions, and those temporary orders are in place now, but we have various requests for temporary orders. In fact, the reason Dr. O'Connor filed the non-suit is to prevent us from proceeding on our request for temporary orders that were going to happen this coming Monday. That was on file.
I object. I'm sorry, Your Honor.
Well,
I
okay.
apologize.
So what is, based on that statement, Mr. Thompson, what is set for Monday?
It's not set because Dr. O'Connor, after he non-suited, he called the clerk's office and disingenuously told them that we are passing it by agreement, which we would not agree to, and he did not confer with me first.
All right. Well,
I object.
counsel,
That's
I'm
not
going
true,
to,
Your Honor.
in looking at the pleadings and the request for time, I'm going to go ahead and grant his continuance. I don't think we can get this done in the 2 hours and 50 minutes we have, and just get a
Respectfully,
reset.
I'm sorry, Judge. Respectfully, I would like to give you the timeline for how many delays he has already incurred on this case. We've been trying to get
I've looked at all of those motions. I've looked at the recusals. I've looked at all of those different events. Mr.
Judge.
Thompson, I promise you, I've looked at every one of them. And, but again, based on your announcement of 2, his announcement for 3, I think this thing's going to have to be set at a time agreed upon between the parties or set. So let's talk about it a date now, so there don't
Judge.
have to be any other settings.
I'm sorry, Judge. I will take 30 minutes if you give it to me. One of the issues is just a motion to compel discovery. So if some of these things need to be continued because they're longer, I would still like him ordered to actually respond to our discovery.
Which is not with all due respect, Your Honor, that's not an independent pleading, as you know, which is required in order to still be considered beyond a non-suit.
That's not true.
That's
That is
independent
simply not
pleading.
true.
Yeah,
It
just
is
don't
a,
talk over each other. The court reporter can't take it.
Yes,
At
sir.
this point, I mean, I can see, obviously from both points of view, I was, with regard to, and I don't have any way to weigh in on, I'm not familiar with the case law you're looking at with regard to the temporary orders, but assuming that to be either true or not true, I do believe that you're entitled, that you have an affirmative pleading in the sense of attorney's fees on your answer. That could certainly be addressed at some point down the road. The non-suit, I don't believe, extinguishes it. The only thing that, the only case law I can find, just in my pre-trial research, which was very thin, I'll admit, is an ex parte Brown that deals with protection and the safety and welfare of the child, as far as that goes. But again, I don't have a pleading to that effect. That it can pass through and not be disturbed by a motion, but that is a 1964 Texas Supreme Court case, and so whether or not that is still applicable in light of statutory changes since then, I don't know. I didn't shepherdize it, so that's kind of where we are. Again, based on the time, and I'm looking at your motion to reinstate. And your notice of hearing. Is there a certificate of consultation about setting the hearing for today, Mr. Thompson?
Judge, I will show you the emails where we communicated on this. I emailed him. I asked.
No, sir, I'm sorry, Mr. Thompson, go ahead. There was no notice of notification for this hearing,
Judge,
of consultation for this hearing,
as
Your
you
Honor.
know,
You just set the
Rule
hearing.
2.2
Don't talk
simply-
over each other's, guys. Mr. O'Connor, you need to stay out of it for right now, okay?
Yes, sir.
You'll be
Thank
given
you.
an opportunity to talk, but not over the top of him. All right, go ahead, Mr. Thompson.
Judge, my understanding of Rule 2.2, it does not require absolute agreement on settings. It requires reasonable attempts to confer in order to do so. I can show the court the email where I attempted to do that and where Dr. O'Connor's response is simply to frustrate and not assist. If I can share screen, Your Honor.
Well, and again, that kind of goes back to the merits of his motion to strike, does it not?
I mean, I suppose, but I can show you exactly what our communication was. I email him on April 26th, and I say, I'm resetting our motion for interim fees, motion to compel for May 18th, 19th, or 20th. Let me know which of those days are immovable conflicts. He responds and just says, I'm not available on those days. I respond and say, please let me know if you're available on any days before our hearing on May 23rd. He does not give me any available days. After 3 or 4 more emails back and forth about the non-suit, we set it because we have not, after attempting to confer, have not been able to agree on a setting. That is all that Rule 2.2 requires. If it requires the other side to say, I would love to set it on this date, then there's no way we could proceed on this case.
I understand. Mr. O'Connor, you can unmute at this point, your comments and observations. You're still muted. If you'll do Alt A.
Yes, sir. Thank you, sir. I'm so sorry. That was the communication, but a fair amount of time had passed and there was no further communication until suddenly I get a communication of a notice of hearing. And prior to that notice of hearing, in checking the docket on a daily basis, I discovered that this setting was made by Mr. Thompson without my knowing. And so that's what prompted me subsequent, a week or two ago, to ask him to please cancel that setting. And then he gave me his notice of hearing. And so after his notice of hearing, I decided to put forth a notice of hearing as well for the non-suit sanctions, dismiss, and strike, sir.
All right,
would
final
like-
comments, Mr. Thompson.
Yeah, I mean, just at a high level, Judge, I'm not sure what else we can do. If I tell him I want to set out one of these dates, he doesn't tell me why he can't, just says, no, I'm not available on any dates. And I say, just give me any date before our temporary orders hearing. And I ask him to do that. And instead, he hauls off and cancels that temporary orders hearing without telling me. Frankly, Judge, I think that Dr. O'Connor is taking advantage of the system to continue to victimize my client using the legal system. What he does is he shows up, he files nonsensical pleadings, and then on the day of the hearing, he files a continuance. What remedy do we have? He should be sanctioned. My client has incurred thousands of dollars in fees preparing for and attending this hearing today, and there is no reason that I can tell her that next time that you set this, that he will not file a continuance on that day too, and I'll be fighting the same battle. I don't know what I frankly, I understand the court's position. I don't understand why Dr. O'Connor thinks that he should not be required to have court on days where he's in possession, but my client should have court on days where he's in possession. That makes absolutely no sense to me. I do not know why he has a dentist appointment scheduled on a day. He is a experienced litigant at this point. He has been in dozens and dozens of hearings. He knows how the central docket works. He says that in his pleadings. I have no idea why he would suddenly say that he doesn't agree to the time announcement or that he's not available for this hearing. I understand that the court sees
what we're going to do is, Dr. O'Connor, give me a date when you're available.
I prefer a morning time, and looking at the date, latter part of June or sometime that's not on a Thursday. In response to Mr. Thompson's follow-up comments.
Once school's out, Thursdays generally fall off after school's out?
Yes, sir.
Standardization order.
Yes, sir. And there was a planned vacation at the 2 weeks of June, with all due respect, sir.
Okay, what 2 weeks?
The first 2 weeks of June, 2nd through the 17th.
Okay. So if we set this, you'll be back. If we set this the 22nd, 23rd, or 24th, at that point in time, that is a Wednesday, Thursday, Friday. Give me one of those 3 dates.
Wednesday, the 22nd.
All right, we'll set it to 22nd at 8:30. I am going to make a notation that I am entering an order. There will be no more continuances.
Yes, sir.
Judge, with all due respect, first, why would it be fair that hearing dates can only occur on my client's periods of possession? His position is just if he's in possession, he's not available for a hearing, and that we have to set this over a month out. I've been trying to reach the court on these issues since January, and he's now saying he can't be available until the end of June. Second, Judge, that's another short docket, and if the court's ruling is that we can't hear all of this stuff in 3 hours, we're going to have the exact same problem.
Well, I'll give you a preferential setting for the 20th or 21st, or the 20th, I mean.
May I respond, Your Honor?
Yes, sir. If
Usually
you're going to
the
hold the
past court-
3 hours and he's going to hold it 2, we're talking about 5, which means it'll have to be a Monday.
Judge, unfortunately, the 22nd, the courthouse is closed for Juneteenth observance, so there won't be a docket on the
22nd, but I'm saying the 20th long docket.
I misspoke. There's no long docket on the 20th because that's Juneteenth courthouse.
Okay, so they'll move it to the 21st.
They won't have a long docket that week, at least how I'm reading the docket. But let me double check.
All right, Mr. O'Connor, look at 27th.
Yes, sir.
That or
That's fine.
and we put it on long docket, and I will get a hold of Jacob, get it preferentially set, and it will there'll be no other continuances.
Yes, sir.
Judge, I don't know what else to say.
But I believe that the disposition of the non-suit has to occur before we can chase some of the other stuff you have pending. I think it all needs to be heard by the same judge.
Well, Judge, at least
Yes,
our
sir.
discovery requests are almost exclusively relating to his finances and his income and his money. That goes directly to my attorney's fees request, which we all agree is live. Just order him to give me the stuff that he's refusing to give me.
Again, I'm not going to indulge in that hearing. We will have the continuance. I apologize, Mr. Thompson, but I believe that's the best way to handle the hearing.
Judge,
So that's what we're going to do. Mr. O'Connor, you need to tender a proposed order to Mr. Thompson that grants your oral motion for continuance, sets it for trial on the 27th at 8:30, and has the language of no more continuances. And if you prefer, I'll have Mr. Thompson do it.
I'd rather prepare that.
All right.
Judge. And Judge, I would
Did you
ask.
say you could prepare?
Yes, I will prepare
I
that.
beg your pardon, Mr. O'Connor. I couldn't hear you. You guys were talking on top of each other.
I was just going to ask if I could have this done by tomorrow. I have to go pick up my son, but if Mr. Thompson is willing to do it, I can certainly
Okay.
yield to that.
Mr. Thompson, you're it.
Judge, I would
And
ask that
I'm
the court.
sitting on and off for the next 3 weeks, so it won't be a problem if you send it once it's drafted to the submission docket. They'll get it to me for entry.
Judge, I would ask that the court order Dr. O'Connor to appear and be present.
And that is that will be incorporated in the order that by agreement the parties have stipulated in order to appear on June 27th. Thank you for your time,
Sir,
gentlemen.
may I be excused, sir?
Yes, sir.